Good evening. My name is Kimbriell Kelly. I'm the Washington Bureau Chief at the Los Angeles Times and a former investigative reporter at the Washington Post and Pulitzer Prize winner.
This is Kay Stevens. I'm a news reporter with the Altoona Mirror in Altoona, Pennsylvania, a newspaper in central Pennsylvania.
Hi, my name is Ed Silverman, and I'm a senior writer and Pharmalot columnist at Stat News, which was launched 6 years ago by the Boston Globe. It's a dedicated website that tracks health and life sciences matters, including the pharmaceutical industry.
Today, we're going to talk about court records and access to them. As investigative reporters, we have a good group between the three of us to talk about this issue. But first, I want to dig into court records and why they're important and relevant. As many of you know, that it's not the easiest thing to pull information out, but as an investigative reporter, the main goal is to shine light on things that are hidden. And with court records, we do just that. I've worked on many stories in my nearly 20 years as an investigative reporter. As I mentioned, many that have led to state law changes, federal changes. But one thing is very common is that court records have opened the door to reveal things that had not been known. A lot of my work has been around police accountability. And I've written stories about police officers who have been charged with things like sexual assault, not only charged, but convicted. And those court records illuminate those things that the public was unaware of, and in many cases had never been reported before. And so, as I mentioned, a lot of that work has led to awards, but a public awareness. A few years ago, I did a series called Fired, Rehired. And essentially, we went to some of the largest police departments in the country and got court records about their officers who had been fired and then reinstated to those same departments, often by some of the same police chiefs that had tried to get rid of them. In many of those cases, we relied on court records to show the background and the history of many of these officers. Sometimes they had been fired from other departments for things that were quite questionable. And in other cases, there were many obstacles where officers, what had happened may have been the discussion of a grand jury, but we weren't able to access that. So obviously, even though court records illuminate a lot, there are a lot of limitations. As the media landscape changes, it's quite expensive to pursue litigation. And many reporters just don't have that at their disposal. And so that's one main obstacle, but as well as time. Many years ago, reporters can send a public records request at a state level or a federal level. And, it could come back in a year or 2 years and the reporter would still be employed at that same agency. Well, today, that's not the case. Reporters move around and they may not be in an organization for 5 or 10 years, sometimes not even as many as 2 years. And so what you find is that time is not on our side. But as we know with public records and the court system, it takes a while. So I would say some of the main obstacles, at least from my perspective, is time, but also the resources and financial resource to do this kind of work. And we're going to talk about that today because Reporters Committee offers some of those resources, particularly for reporters who may not have them or they have to have a large media organization supporting them. Ed, you've done a lot of work, particularly around Purdue Pharma and court records. Can you talk a little bit about that?
Well, I've been covering the pharmaceutical industry for 26 years now, lost track. And during that time, I've covered a lot of different types of litigation. Early on, in this case would have been the late 90s, much of it centered on product liability litigation, for instance, where someone or thousands of people would sue a drug manufacturer over undisclosed side effects or side effects that popped up later that caused some sort of horrific harm or alleged harm. And I've noticed over time, but even starting then, that all too often there were agreements reached to keep certain information redacted or sealed. It's a trend. There's always the possibility for a legitimate argument for agreeing to that kind of request, but the outcome nonetheless is less information. And the issue and concern came up in a big way with Purdue Pharma. at Stat News, we actually had someone else who was initially covering Purdue early on, and we fought aggressively in a state court to obtain records that we knew existed, specifically concerning a lengthy deposition of one of the senior Sackler family members, whose comments shed extensive light on the role, the influence that some of those family members played on the company in the marketing of their OxyContin drug. So from 2015 on, we were actively involved in pursuit of information that in one court or another was not readily available or easily obtained. Going forward, the Reporters Committee helped that goal considerably because of the resources and because of the smarts. And it wasn't just the formality of the procedural act of having one or more attorneys file motions in court. It was being able to identify, whenever possible, which documents might be useful to reporters. For example, in my instance, I would get any number of documents that were successfully obtained. And when I had questions, I was able to get some information about what the legal considerations were, what the procedural expectations were going forward, but also sometimes to interpret what the documents seem to suggest in terms of importance, but also just pure fact. So this was a really important effort that helped with our reporting and our interpretation for our readers. I mentioned how the committee helped us obtain documents, and those turned into stories. Two stories in particular that stood out in my mind. One involved documents that indicated how the Sackler family members who controlled Purdue Pharma maintained that they had not foreseen the extent of the litigation, the large number of lawsuits filed against their company, the drug maker. And therefore, as a result, even though they had been transferring billions of dollars over time out of the company to whichever financial accounts, they insisted that this was not what's known as a fraudulent conveyance, an illegal, improper act to shift and hide money. And this is very important when you step back and try to understand the extent to which the Sackler family members were hovering over the control of the company, how they benefited, how they profited, and how the decisions that were made affected the company and its finances. Because one of the key larger issues here during the Purdue bankruptcy and leading to the bankruptcy was the control that the Sackler family members maintained. That some were board members for many years, and they each had all sorts of financial entities established, not just in the US, but in other countries. So a legal issue that was being picked over concerned whether any of those funds that were taken from the company were effectively put into their own individual pockets. And therefore that spoke to motive about how the company was managed and how the company's finances were handled. So the documents that we obtained explored some of the comments that were made by individual Sackler family members over time to try to shed some light on their thinking and how that might have affected the way the finances played out. Another example concerning a story that I thought was particularly helpful and also important, thanks to the work of the committee, involved documents showing the work performed by the McKinsey consulting firm that Purdue had hired. McKinsey, which of course is extremely well known around the world, in this particular case had suggested that Purdue pay or consider paying rebates of up to $14,000 to health insurers for each patient who was harmed by the OxyContin prescription opioid painkiller. This was significant because it spoke to the concerns that Purdue had to not only maintain revenue, but to somehow scramble in response to the growing number of harmful outcomes caused by the company's painkiller. And the purpose here was to pay from $6,000 to $14,000 to each person who is covered by a health plan. Not pay that to the person, but to the health plan for each of its members who experienced harm due to OxyContin. And McKinsey, this was part of McKinsey's larger role in advising the Purdue company and its board on how to handle the fallout from the growing number of opioid addictions and deaths. And this, of course, led to more insight and understanding into the role McKinsey played in this particular instance and the importance the company plays when advising companies. And if you want to have this discussion beyond just the legal issues, the medical issues, it also raises to some people, and in my mind, ethical issues about the extent to which it should be paid to keep health plans interested in covering your drug when it's clear that there's harm being caused. Some might say it smacks of a payoff. I'll let others decide that. But this is the sort of issue that has come up in the Purdue bankruptcy and helps decide issues such as intent when it comes to how the company conducted itself. So that's what we were doing at STAT. Obviously, those are sweeping sorts of national issues that can affect policy and law and all sorts of different things. But there are other ways of coming at this, looking at this and sorting it out from more of a local, regional perspective. And that's where I'd like to turn to Kay to explain how she did what she did in making use of the documents and making sure that the work was properly and helpfully understood by her readers in her particular corner of the world.
Well, thank you for that introduction, Ed. I am thoroughly a local news reporter out here in the middle of central Pennsylvania, and a lot of the kind of cases that you deal with start at my level. And because as a local news reporter, the records and the documents that can be found at your local courthouse, they're the fountain of news stories, even in a community like mine. They're very important in explaining the kind of basic details that go into a controversy and why one side might take one position and another side might take another position. So that's why I saw this red flag a few months ago. I noticed a local judge's reference to sealing the records in a civil court case, and they relate to a criminal court case that I've been following regarding this local wrestling coach. He was a junior high school wrestling coach. And he was charged with child sexual assault involving 2 student wrestlers on school grounds. Now, while these criminal cases have been fairly open, I haven't had too much trouble getting access to those. The judge in the civil court case, he took the words of the attorneys in those cases and saw that, there are some sensitive matters in this case. So he sealed these records. Now, that to me was a big red flag, because I was well aware of another civil court case in my own county where these records it involved a priest and an abuse case. And in that case, there was a lot of time that passed between the filing of that civil case and a judicial decision saying these records should be open. So I'm thinking there's no reason for these records to be sealed, especially because I've got the criminal court case going on in a neighboring courtroom. So anyway, I'm getting concerned about this, and I go knocking on the door of the judge, and I say, you know, what's going on here? And he's like, well, you know, the attorneys, they both asked me to seal the case, and so he says, but I'm willing to revisit it. And it's like, oh, all right, well, if you're willing to revisit it, it sounds like I'll get access to these cases, these court records eventually. But then he doesn't. He comes up with a modified gag order and what they can talk about regarding these cases. And I have to explain to him, look, I need access to the meat and potatoes of these civil court cases, these documents. I need to know what they're saying about each other. And I had to explain to the judge that that unlike the criminal case where, yes, I'm getting the details on who's accused of what, who's saying he did this, who's saying he took these school wrestlers, he took advantage of these school wrestlers. But I said, but the civil case focuses on the school district personnel, what they did, what they didn't do, who's responsible, and whether our local taxpayers are going to have to pay out any money, even through their insurance company, even through the school district's insurance company, in order to deal with this case. So anyway, I was lucky to get to turn to my statewide newspaper association, news media association, for some help. They have an excellent attorney there, Melissa Mizuski, and Melissa was able to direct me to the reporters committee. And that put me in touch with attorney Paula Burke. And she has been very good at giving me the legal reasons as to why I have the right position that these cases should be unsealed and that we should have access to all those court records. That's very important to me. I like to tell my community what's going on, and I feel like I'm handicapped by this seal on these records, and I'm still in the process of fighting the seal. Kimbriell, I understand that the Reporters Committee attorneys recently represented the Los Angeles Times in a couple of court cases. Maybe you could talk about how the newspaper's fight to access those search warrant records was very helpful to your organization.
Yes, the Reporters Committee has been very instrumental. We've been working with them most recently on a couple of different cases. Obviously, we're in the same circles when I go to Investigative Reporters and Editors Conference. It's always very nice to see the attorneys from Reporters Committee there talking about the work that they do. And so, you know, to be able to work with them on a couple of occasions recently has been great. One case is ongoing, and the other one we have some resolution already. And so the first one I want to talk about, obviously, is something that has been on all of our minds with January 6th and the riots at the U.S. Capitol. You know, there was a lot of video as we look back of what happened that day. And in one of those videos, there is a person who's, you know, there were a lot of people who were standouts, but there was a guy there who was tall, 6'6", and he was recognized. And it turns out that he was a former USC student, but more importantly than that, he was an Olympian. And he was an Olympic swimmer, and he was arrested on criminal charges for his alleged participation in the January 6th riot. And so his name was Kimbriell Kelly. And so obviously that was of interest to us. And so there was a search warrant that was issued, but those records were sealed. And it goes back to what we were talking about earlier this evening, being able to access those records. And if you have the money to afford to do that, and if you have the time, well, we wanted those records. Obviously, we wanted to know what were in those search warrants, what was the information that the government had, and that made them go out to his house in Colorado Springs, and what were they searching for? And so we worked with Reporters Committee to actually intervene on our behalf in that case. And so reporter Nathan Fenno, he's been closely following that for the LA Times, as I said, because obviously, his connection to USC. But we were able to get some decisions in that case. And so Reporters Committee filed a motion to intervene to unseal those search warrant records and related records. And after we filed our motion, essentially the government decided that they didn't want to defend the withholding of all of that. And so they unsealed and unrestricted most of the search records, search warrant material that we were requesting. And so it was interesting to find that, some of the things that they were looking for, articles of clothing, which would identify Clete Keller, but more specifically, his US Olympic jacket, the bandana face covering that he was wearing, the backpack that he was wearing, the logos that were on the backpack, his digital, his computer, his technology, who had access to it, who had ownership of it. I'm reading all of this information and you're reading it and you're saying, this is the evidence to tie him there, to tie him to that date, to tie him to the clothing, to tie him to the video. And so our reporters, we were able to use, working with the reporters community, get this information and report this out. And that's very significant. This is a man who's a gold medalist. He had gone to multiple Olympics and he was right in our own backyard, but also he participated. Well, now the government had this, I will say, the government had these records now showing why they felt like he was connected and why they should charge him with these crimes, including disorderly conduct. And so that was significant. And that's information that we would not have otherwise had because it was sealed without the Reporters Committee. And again, most journalists, if they're working in a lot of organizations, they're not going to get an opportunity to file lawsuits, to intervene in cases like that. That is just not the reality. That goes into a wish list. But here we were able to do that. And then there was another case that was very interesting. Obviously, right now, we're all still dealing with the impact of the coronavirus. But last year, just in the spring, when people started getting ill, we thought it was the flu, a late version of the flu. We didn't know what was happening. But at that same time, there were some things that were happening in the federal government. There were health briefings. And one of those people who were briefed about that information was Senator Richard Burr of North Carolina. And we were reporting on this. At the time, he was the GOP chairman of the Senate Intelligence Committee, but he had been receiving briefings from health officials about what was happening. And something interesting happened shortly after those briefings. He began to sell off stocks. And he began to sell off stocks to companies that were related. And it turns out he sold a significant percentage of his stock portfolio. And I'm just going to read my notes because I want to get this right. There were, on February 13th, 30 different transactions that he had selling off his stocks. They ranged in amount from $628,000 to $1.72 million. The federal government was clearly interested in finding out, had he taken this information, this insider information he had right before the pandemic got crazy and people literally weeks later started losing money, the stock market was crashing. Did he use that information to benefit himself? Obviously, with the federal government, if that were the case, he would have violated the laws that prevent members of Congress from trading on insider information. And so the government wanted to know that. So we got a scoop. Our reporter, Del Wilbur, he found out that federal agents were seizing the senator's cell phone. This is a sitting US senator, the chairman of the Senate Intelligence Committee. And we ran the story. But not only did we want to run the story, we wanted to know, what did the federal government have in that affidavit to even get the search warrant? And that information was sealed. We couldn't get access to it. The same way that Reporters Committee helped us with the Clete Keller case, we said, well, maybe they can help us with this one. So they intervened on our behalf. We have not been as successful as of yet. The case is still ongoing. We were initially denied access to those records. And we earlier this year filed an appeal. And so that case is still pending. But imagine what kind of information that they had. and what the stories will be when we're able to access that we have a powerful senator that may have taken this information for his own gain to prevent severe and extreme financial loss. Again, it goes to the whole heart of investigative reporting, shining light on things that are hidden and that the public needs to be aware of. These are government officials, elected officials. And, the action was swift. After that happened, the very next day, Senator Burth stepped down as chairman temporarily over that committee. And as I said, the issue is still ongoing, but we'll continue to follow it. And so in the Clete Keller case, we had a quick victory. This one, we filed appeal. We're still waiting, but we're hoping to also be victorious. But those two cases would not have happened without our participation and ongoing support of Reporters Committee.
Well, it was great to be with you, Kimbriell and Ed. I appreciate hearing about the problems that you're dealing with as far as accessing court records and documents. It certainly is a task with which we need help. I'm very appreciative to have the help of the Reporters Committee on my issue that I'm dealing with. Because while I may always have the desire to get the records unsealed, the attorney that I'm working with, Attorney Paula Burke, she's got the legal expertise to explain why the task should be accomplished. And I wish the best of luck to you, to both of you.
I'd just like to add that the committee helped us do our job in a better way, because at the end of the day, the Purdue Pharma imbroglio wasn't just a court case or a bankruptcy or involved side effects or a wealthy family. Unfortunately, it spoke in total to a very, very large national public health crisis that would not have been otherwise perhaps fully or even properly understood without the sort of deep diving that can be done from gaining access to documents that the committee helped us to obtain. And I think at the end of the day, that speaks to what Kimbriell was saying, that without this sort of activity, without this sort of resource, that work can't get done. And if we can't achieve that when there is a matter such as a public health crisis, then we all lose, because policymakers lack the information on which to act when it comes to exploring and examining what needs to be done to correct the system gone awry, or simply improve a system that is already in place.
That's the goal of investigative reporting, is to shine a light on things that are hidden. That support comes from places like the Reporters Committee, who helps, as you heard this evening, organizations large and small. You don't have to be some very large newspaper like the Los Angeles Times. You can be a solo reporter with a great issue and a great story to tell. And so that is one of the phenomenal things of Reporters Committee. As publications start to pull back on resources for litigation, there's an organization like this that continues to push forward with reporters on these massive issues of public access. And so, it's great to have that support in these two cases, but I look forward to a future where reporters can continue to rely on the organization for that kind of support.